Yesterday, Luke discussed parts 1 and 2 of the Legal Services Act in an explanatory video and article. These parts of the Act came into force on October 14, 2022, according to a government press release. As readers will recall, those parts covered definitions to be used under the Act and the procedure for the establishment of the Cayman Islands Legal Services Council. In the second part of this explainer, sections 99 and 101 of the Act will be discussed. The government press release also said that these parts came into effect on October 14, 2022. So first, let's get into section 99. In relation to section 99, this allows the cabinet to make regulations covering access to legal profession and training and development of attorneys at law. According to the Act, the cabinet can make these regulations after consultation with the Cayman Islands Legal Services Council, which, as mentioned yesterday, is expected to include political appointees. In addition to the concerns raised regarding the council comprising political appointees, its general structure is expected to cause controversial issues in connection with the mixing of powers of the court, legislature, and cabinet all in one place. This may ultimately lead to questions about possible conflicts of interest in the operation of the council. Before going too far off topic, though, let's dive in and examine the types of regulations that one can expect the cabinet to consider and pass under Section 99. In this case, the source of guidance for what one may expect in the 2022 regulations is the content of the 2019 consultation draft regulations. In connection with this, the 2019 consultation draft covered the type of firm that the regulations would apply to, the requirement for such firms to have a scholarship program in place, how scholarship recipients could win contracts to train with the law firm, and what happens after their training is complete and they're finally admitted to practice Cayman Islands law. So first, let's look at the type of firm. According to the 2019 consultation draft, the proposed cabinet regulations were contemplated to apply only to a law firm that had over 15 attorneys at law that hold practicing certificates. The 2022 regulations are expected to take a similar shape in this regard, as smaller firms may have challenges with satisfying the regulations due to their size and resources. Let's now turn to the scholarship program. The 2019 consultation draft required a law firm to establish and maintain a scholarship program and provide a scholarship to at least one Caymanian at all times. Again, one would expect this to not change in 2022 unless firms wish to be more generous and commit to scholarships to 3 or 4 Caymanians at all times. Next, let's look at the requirement for training contracts or articles of clerkship. In relation to training contracts or articles of clerkship that a scholarship student may win at a law firm after he or she has completed his or her law studies, the 2019 consultation draft generally says that the relevant law firm will first look at its list of scholarship students that it already sponsors. The law firm would then interview the persons on that list for a chance to complete a period of articles or training with the law firm that will ultimately lead to the person qualifying as a lawyer. However, the ability to win this prestigious seat may depend on how well a student does at university, that is, the achievement of first-class honors or second-class honors, etc. If the 2019 consultation draft is followed, it may also mean that any student who was not on a law firm scholarship program, but who has a degree, may be left out of the race for a training contract. Unfortunately, the manner of the preparation of the 2019 consultation draft does not offer much certainty in terms of the sponsored scholarship student being allowed to complete his or her post-law degree training with the very firm that gave him or her a scholarship to do the law degree. One might therefore expect the 2022 regulations to provide more certainty for law school graduates in that they will all be offered training contracts upon completion of their degrees after having been sponsored by the relevant firm. Now, what happens after you finish your training and you get called to the bar? Well, if one follows the text of a 2019 consultation draft, one will see that once a law student completes his or her degree and training for 18 months with a law firm, that person will be offered an interview for an associate position that is a full-time job with a relevant law firm. As an improvement, one might expect that the 2022 regulations provide more certainty for trainees or article clerks so that once they finish their training under the guidance of a law firm partner, they will all be offered a job as an associate with the relevant firm. Otherwise, there will be little or no job certainty for these persons. Next, let's look at what happens when the person is hired as an associate at the law firm. How involved are they with the business development? Well, if the wording of the 2019 consultation draft remains in the 2022 regulations in the case of business development, the implication is that Caymanian lawyers will only be eligible to participate in the law firm's business development activities after they have been with the law firm for a minimum number of years. Such a regulation could be challenging if it appears in the same format in the 2022 regulations. This is because it may mean that a Cayman attorney working for a competing law firm for 10 years and then transfers to a new law firm would not be allowed to participate in the law firm's business development activities until he or she has been with the new law firm for a minimum number of years. As an alternative, another approach could be for partners to analyze each Cayman attorney based on their abilities and contributions in terms of billable hours and other factors to determine inclusion in the firm's business development activities. So what happens after the person qualifies as an attorney, gets their training, does business development, brings in new clients? How can they become a partner? Again, using the 2019 consultation draft as a guide of what to expect in the 2022 regulations, after a period of at least 10 years, a Caymanian lawyer would be expected to be in a position to apply for a position as a partner in a law firm. Now, this is not expected to change in the 2022 regulations, as it is industry standard for an attorney to reach at least 10 years before being considered for partner. I should note, however, that becoming a partner is never guaranteed to anyone, as it is based on a high level of performance, including billable hours, winning clients, and being likable by other partners in the firm. One adjustment for the 2022 regulations, however, is that mention should be made that Cayman attorneys can qualify as equity partners in addition to being salaried partners. And now we get to the good part, the ratio of Cayman associates and Caymanian partners in firms. If the goal in the firm is to have as many Caymanians as possible who are partners and associates, then the ratio approach mentioned in the 2019 consultation draft might be applied in the 2022 regulations. The ratio approach stated in the 2019 consultation draft was that a law firm that has a business staffing plan shall maintain a minimum number of article clerks in accordance with the business staffing plan submitted by the law firm to the business staffing plan board. Something similar could appear in the 2022 regulations in relation to associates and partners. That is, a suitable ratio of Cayman associates to non-Cayman associates and Caymanian partners to non-Caymanian partners. Whatever the ratio is, however, is whatever would be agreed by the relevant law firms as reasonable. Now, after significantly fleshing out the possibilities for regulations that Cabinet can make under Section 99 of the Act, one can now examine what savings and transitional provisions might be included in the 2022 regulations. For illustration purposes only, such provisions may include the following. Number one, allowing any period of recognized training entered into under the old regulations to continue as if recognized under the 2022 regulations. Number two, permitting any approval, authorization, or recognition granted under the previous regulations to continue as is granted under the 2022 regulations. Number three, allowing persons who work outside the Cayman Islands and who practice Cayman Islands law, but who do not possess a Cayman Islands legal practice certificate to continue to practice Cayman Islands law for a period of time after the regulations are passed. And now, the reason for these types of provisions is to allow certain parties time to comply with new regulations in the event that the regulations were passed so quickly that the parties did not have sufficient time to comply. These types of savings and transitional provisions also allow for a smooth transition from the old regulations to the new regulations.